It's barely 2 weeks to the termination of the National Assembly tenure, and the orders made by the Supreme Court on Monday will be properly situated in this contest. The Apex Court had on May 8, while listening to an ex parte application by the Attorney General of the Federation, directed the National Assembly to stay action on the attempt to override the President's veto on the Constitution Amendment Bill. The Supreme Court then adjourned the case till June 28. Over 3 weeks after, the tenure of the National Assembly would have ended, thus rendering the efforts of the National Assembly to amend the Constitution a nullity. Although members of the National Assembly expressed outrage on the developments, they nonetheless obeyed the order and directed their lawyers to file an urgent application and bring the hearing date forward, which was why the case came up on Monday. Efforts by the counsel to the plaintiff to amend the defects initially pointed out by the court were rejected by the Supreme Court's panel, presided over by the Chief Justice Mahmood Mohammed, who upheld the objections of Adegboyega Umolu.
They proposed to amend 65 sections of the Constitution. The only areas we're complaining about are 10 out of 65. So, I mean, it's almost next to nothing. When the two parties sit down, they can iron the gray areas.
If it's fundamental, it cannot be, but it's not fundamental. It's just, in my view, slight issues of procedure.
At the end of the day, the Supreme Court directed both parties to meet on the issue, resolve their differences, and report back on Wednesday. Wumi Obaburi, AIT News, Abuja.